Peter Erlinger, you're a professor at the William Mitchell College of Law in St. Paul, and you wrote an article describing what the Anishinaabe think are off-reservation hunting, fishing, and gathering rights in the ceded territory of Minnesota. What is that argument?
Well, it's actually not just what the Anishinaabe think, it's what the United States Supreme Court thinks. The United States Supreme Court has decided that prior to there being any treaties, the Anishinaabe had hunting and fishing rights that, of course, were their basis for survival. After the Europeans arrived, there were a series of treaties. The first two, the 1837 and 1854 treaties, specifically mentioned that the Anishinaabe retained hunting and fishing rights in the territory that was ceded. But they also did nothing to take away the pre-existing hunting and fishing rights in all the territory that hadn't been ceded in those treaties. None of the treaties that ceded land after 1854 gave up hunting and fishing rights. According to the U.S. Supreme Court, therefore, the hunting and fishing rights that pre-existed the treaties are now have still been completely undisturbed and should be recognized even today.
Have there been any agreements between not the Mille Lacs, but the Leech Lake Band and the White Earth Band renouncing these rights with the state of Minnesota?
No, there's never been any action by either the federal government or by the state government that the Supreme Court has recognized as giving up those rights. In fact, the state of Minnesota has recognized that the 1854 treaty, which cedes part of Minnesota as well as northern Wisconsin, retained the hunting and fishing rights in Minnesota's Arrowhead. That same treaty said that the areas west of the treaty line were unaffected by the treaty, and therefore the hunting and fishing rights as of 1854 existed in both ceded and unceded territory in 1854, and nothing has happened since that time to remove them either from the ceded territory or from the unceded territory. The rights simply continue to exist today.
We've been through this process in Wisconsin. What emerged from that was the Great Lakes Indian Fish and Wildlife Commission, which effectively engages in co-management with the state of Wisconsin right now. What we're wondering about is, does that operate like that in Minnesota, or can an Indian man or woman be busted for hunting off the res in Minnesota?
In most of Minnesota, they can be busted for hunting and fishing off the res, and regularly are. In the Arrowhead, however, the state of Minnesota has recognized that the same hunting and fishing rights that exist in Wisconsin exist in the Arrowhead region. There's two ways for the state to deal with that: either to set up or agree to a co-management system like has happened in Wisconsin and has happened with the Fond du Lac Band in part of the Arrowhead, or the bands can agree to lease their hunting and fishing rights to the state in exchange for payments to the band, in which they agree that the state will manage the land and the hunting and fishing rather than the co-management with the band. That's a decision each band has to reach.
There was some remarkable language in the argument saying that since 1854, there should have been consultation, or what we call co-management, between the states of Minnesota, Wisconsin, Michigan, and the bands. In the 80s, we almost thought that was a pipe dream, but it isn't.
It's not.
It isn't a pipe dream.
No, it's not. It's the law of the land as declared by the U.S. Supreme Court, not me.
John D. Rockefeller took away a lot of iron ore from the range. The Calumet and Hecla mine, owned by the Agassiz family from Harvard, took a lot of copper. What does that suggest to us in this era? What does that mean?
Well, first of all, there were some very early agreements before the territory was ceded where the Anishinaabe, or groups of the Anishinaabe, had agreed that there could be mining on the land. They didn't agree that the mining could take place without paying for the mining, and they didn't agree that their ability to hunt and fish on the land would be diminished in any way. So the situation that we have now, according to the U.S. Supreme Court, makes clear that when the investments were made for the U.S. Steel owning the Mesabi Range and the mining in the Upper Peninsula in Wisconsin, all of those affected the ability to hunt and fish in those areas. And to the extent that the mining affects the hunting and fishing and ability to live from the land, the state and those companies have to negotiate with the Anishinaabe to make certain that however they use the land is not going to diminish the ability of the Anishinaabe to live from the land. In reality, what this means is the Anishinaabe are in the position to protect the wilderness for all of us. And for the sportsmen who are complaining about this, they should understand that it means that a major corporation cannot come into your town, buy up the mineral rights, and rip up the mountains like are going on with the coal mining in West Virginia and is going on in the Arrowhead in Minnesota. It would mean that the ability of the Anishinaabe to hunt and fish on that land will also protect the rights of outdoorsmen to hunt and fish on the land and not to have it changed to a different purpose that makes it impossible to enjoy the outdoors or the wilderness the way that many of us do.
One more question, Peter. The diabetes, the heart disease, the obesity in Indian country, probably directly related to giving up the hunting and fishing and gathering way of life for this past century and a half, correct?
Well, I'm not a nutritionist, but the human race were hunters and gatherers long before they were farmers. And hunting and gathering means nuts, berries, protein, not much sugar, not much carbohydrates, and the kind of illnesses that you're talking about result directly from a huge influx of carbohydrates into our diet. So a hunting and fishing diet would have very few carbohydrates, which means not much diabetes, not much overweight.
So as a human rights attorney, you're involved in Rwanda right now, you have an international reputation. As a human rights attorney, do the tribes have damages coming from this century and a half of probably illegal action by the states of Minnesota and Wisconsin?
Well, I think that's a bit speculative, but in the paper that I wrote, at least from 1988 forward, when the state of Wisconsin and Minnesota recognized that they had to co-manage the hunting and fishing rights or pay for the privilege of using them, the state of Minnesota has paid a little over $20 million to the bands in northern Minnesota that have leased their hunting and fishing rights to the state. The area that is covered by the rest of the rights of the Anishinaabe to hunt and fish is 3 times the size of that area. And if we use that standard, we're talking just since the late 1980s of hundreds of millions of dollars.
Is there anything you'd like to add?
I think that's sufficient, except that my hope is that people who are concerned with being able to use the wilderness, of which I'm one, will recognize this as being a good thing for all of us, not just for the Anishinaabe.
This is Nick Vanderpye and Peter Erlinger for IndianCountryTV.com at the William Mitchell College of Law in St. Paul, Minnesota.